Steve Hallbrook, Second Amendment attorney and scholar, joined us on the program. Steve, good evening to you, sir.
Well, good evening. I didn't want to miss all the fun.
Well, listen, I'm glad that you're around, and I was really fascinated by your piece at jurist.org. I have to say, not one of my usual haunts on the internet, but when you're writing there, I'm going to read it. NRA versus BATFE, a misinterpretation of history. And you were writing about the recent case out of the Fifth Circuit Court of Appeals, right?
That's right. There was a challenge mounted on behalf of persons aged 18 to 20 to challenge the law that is in the Gun Control Act prohibiting licensed dealers to sell firearms to persons in that age group. So the purpose of that lawsuit was to establish that, well, look, persons in that age group can serve in the military. They can bear arms for their country. They can also vote under the 26th Amendment. They have full rights of citizenship, so it doesn't make any sense that they cannot qualify to buy a gun. Note that they can possess guns. Private persons can sell them guns. The only thing that cannot happen is that a licensed dealer cannot sell them a gun, meaning that they're prohibited from buying a gun, getting the NICS check, the National Instant Criminal Background Check. So it's a very weird law in that respect.
Absolutely. All right. Now, we've talked about this on the program. The Fifth Circuit upheld the law, but you say that the decision misinterprets Second Amendment history and leads to absurd results.
Well, I think what gets me more than the bottom line of the decision is the process the court went through to get there. If we look back at the time when the Second Amendment was adopted, 1791, we had just been through the period when the Constitution was adopted. We had statements, for example, Richard Henry Lee, one of the proponents of a constitutional Bill of Rights, saying that to preserve liberty, it is necessary that the whole body of the people possess arms and be taught to use them, especially when young. We saw the passage of the Militia Act of 1792, requiring every able-bodied white male citizen aged 18 to 44 to possess a firelock, or if the person's a horseman, a pair of pistols. So that's the context of the adoption of the Second Amendment. And what do we have, though? The reasoning by this court was, well, there were a lot of infringements on the right to keep and bear arms in those days. For example, loyalists in the Revolution were disarmed. That's right, they were disarmed. Their property was seized. Their printing presses were seized. Some of them were tarred and feathered, imprisoned, or even shot. There was a war going on. Hello, and to base interpretation of a constitutional right on how that right was violated during a wartime boggles my mind. And then even worse than that, they said, well, in other words, there's a tradition of infringing on people's rights in this country, so you can deprive these 18-year-olds and over of buying handguns from dealers because they disarmed slaves. I mean, this is one of the most tragic things in our history, violations of human rights, that slaves were disarmed so they could keep them in slavery. And so it's like arguing that, well, we've got precedents for violating this right because the Crown disarmed or tried to disarm the Americans. So these are the worst possible examples to establish the meaning of the Second Amendment and how the right can be limited. And these arguments go back to Saul Cornell and others who have tried to make the Second Amendment into a non-right. They write books, they file amicus briefs, like in the Heller case, and Justice Breyer, in his dissenting opinion in Heller, even cited these very same authors that the Fifth Circuit is relying on now.
Right.
And the line of argument is that rights are violated, so it's okay to violate rights, as they were at one time in history. So, it's just a very counterintuitive argument to make. And just one more point is that in the Heller case, the court said, we've got these long-standing regulations like disarming felons and the mentally ill. And so the Fifth Circuit here said, well, we're going to compare people in this age group to felons and the mentally ill.
Yeah, yeah, and so Steve, obviously this is far from over. Not sure if the case is going to be appealed en banc, within the Fifth Circuit, or if it'll be appealed up to the Supreme Court. But it sounds to me like you see a wealth of opportunities to argue that the court got it wrong in this case.
Yeah, I mean, I think they got it wrong in terms of the end result, but they really, really got it wrong in terms of how they got there.
Mm-hmm.
And if you think back, I'm in this generation when they gave the 18-year-olds the right to vote. That was like what in the 70s, I guess. And the whole thing was, if you can serve your country and you can die in Vietnam, by cracky, you should be able to vote. And so you're bearing arms for your country, and you're telling me you can't vote. I mean, I think that might be an argument you'll see more of today as this issue comes to the fore. This won't be the only case of its kind, regardless of what happens in the particular case. I think that time has come to look at persons in that age group, 18 to 20, and to think about the obligations and duties and privileges like voting that they can do, and
Right.
why not treat them as real citizens, and instead of like they're mentally ill or felons.
It's funny, Steve, because we're talking about this in the legal realm, but in the cultural realm, we're having this same debate. Parents of kids who are now up to the age of 26 know that their adult children can now remain on their health insurance, which is something that did not happen. We've all seen the stories in the New York Times about delaying adulthood, delaying kids either through no fault of their own because of the bad economy. They can't get a job. They're going back after graduating from college, moving back home. It's sad. There is this, I think, a philosophy out there that 24 and 25 and 26-year-olds may not be mature as 18-year-olds were even 50 years ago. And what a sad indictment if that's true. But, legally speaking, does that really matter, Steve?
Well, in some cases, I mean, I could also point out the number of young people voting for President Obama.
Right.
An example of people who really don't get it. But on the other hand, when you start looking at the individuals involved, like if you look at our individual plaintiffs in this very case, you've got the most responsible, patriotic, law-abiding young people.
Mm-hmm.
They're involved in competitions. They might be involved in military service.
Yep.
And let them be adults if they're behaving like adults. And I think it's a debate that's going to have to be made because, especially to talk about absurd results, the fact that they can buy guns legally, their parents can buy guns for them, anybody in their own state can transfer a handgun to them.
Yep.
But they can't get it from a licensed dealer where they would get a NICS check.
Right. It's
what's really absurd.
Yeah, exactly right. Hey, Steve, unfortunately, we are almost out of time, sir, but I really appreciate you coming on the program tonight. Fantastic talking to you, and I hope we can do it again soon.
Okay, always my pleasure, Cam. Thank you.